Since this opportunity is given by this honorable court to compare, and we understand that their reluctance to stipulate on these 10 documents is because of their claim that it does not faithfully represent the originals, Your Honor. May we ask also that these 10 documents be perused during the period given?
If only to give it a second chance and a second look, given that not much time was given to the counsel for respondents to view it. They were only given 20 minutes. So, yes, the court will allow it to allow the respondents more time to go over it for possible stipulation. Again, no pressure, Attorney Christine. You don't have to if you don't want to. You don't have to if you don't wish to. But the court just wants to give it one more shot to save on the court's time. So ordered.
Thank you, Your Honor.
Now, before the court makes a ruling on the motion for judicial notice, the court promised to hear and listen to the counsel for respondents either in writing or orally. I have been informed by the clerk that no responsive pleading was given by the counsel for the respondents. So I guess you will be
Your Honor, please.
orally arguing the motion.
If I may, Your Honor, please.
Beforehand, I guess you will be orally arguing on the motion for judicial notice, counsel? Attorney Christine?
We are ready, Your Honor.
Your Honor,
Again,
please.
just to hear your side. Yes, Attorney Kapunan.
At this juncture, Your Honor, I respectfully turn over to our public prosecutor and head public prosecutor, Chairman Jinky.
Yes, thank you, Honorable Luistro. Before I recognize you, Ma'am Hailin, you are excused. Sorry po. You are excused, but you are ordered without need for the issuance of another subpoena to appear once again before this court on August 10 and 11. 10, so in open court, you are directed to appear here once again on August 10. We will be issuing another subpoena should we require your presence again on August 11 onwards. Do you understand, ma'am?
Yes po, Your Honor.
So magpapakita po kayo sa Lunes uli nang wala ng subpoena.
Yes po, Your Honor.
Salamat po. You're excused, ma'am, and thank you for your presence and cooperation this afternoon and your patience. Now, this won't be oral arguments. The court, the chair just wanted to hear from the counsel for respondents. So really, this will not be oral arguments between the parties. Yes, what is the position of the counsel for respondent insofar as certain records of the House Good Government Committee and Public Accountability Committees, if I'm not mistaken. Attorney Christine, you'll be arguing?
Yes, Your Honor.
You may proceed, ma'am, when you're ready.
Thank you, Your Honor. The defense would like to oppose the motion for judicial notice on the following grounds. Number one, the judicial notice rule cannot be taken of disputed matters. Number two, the respondent must be given an opportunity to be heard by way of cross-examination before the court admits in evidence the matters covered by the TSNs, the video recordings, and the committee reports. And number three, the proceedings before the HOR, COJ, were questioned by the respondent before the Supreme Court as a fishing expedition and mini trial. On the first point, Your Honor, judicial notice cannot be taken of disputed matters. In Juan versus Juan, the Supreme Court defined judicial notice in this wise. Judicial notice is the cognizance of certain facts that judges may properly take and act on without proof because these facts are already known to them. Put differently, it is the assumption of a court of a fact without need of further traditional evidentiary support. The principle is based on convenience and expediency in securing and introducing evidence on matters which are not ordinarily capable of dispute and are not bona fide disputed. While the CGGPA and HOR-COJ hearings were made public, we do not dispute that, Your Honor. The matters discussed within them, which were documented via the TSNs, video recordings, and committee reports, are not facts automatically admissible in this impeachment trial. Rather, they remain assertions that must be proven by evidence. We note, Your Honor, that Article 1 of the Articles of Impeachment alleges the following: that respondent, Vice President Sara Z. Duterte, committed culpable violation of the Constitution, graft and corruption, and betrayed public trust through the systematic misuse, misappropriation, and irregular liquidation of confidential funds amounting to 500 million pesos released to the Office of the Vice President and 112.5 million pesos released to the Department of Education. Clearly, Your Honor, these are not just statement of facts. These are accusations of misuse, misappropriation, and irregular liquidation of confidential funds, which must be proven by the prosecution through presentation of evidence. In fact, Your Honor, if you noticed, the prosecution in paragraph 1 of its motion for judicial notice admitted that, I quote, prior to the transmittal of the articles of impeachment to this honorable court, the House of Representatives, through its Committee on Good Government and Public Accountability and its Committee on Justice, conducted official hearings on matters that ultimately formed the factual basis of Article 1. We highlight that, Your Honor, ultimately formed the factual basis of Article 1, which is the misuse and misappropriation of confidential funds. Okay. Article 1 of the Articles of Impeachment, as a continuation. These proceedings were officially documented through transcript of stenographic notes, or TSNs, official audio-visual recordings, and committee reports. I am just reading, Your Honor, I'm just referring to the motion of the prosecution. Thus, we cannot take the TSNs, the video recordings, and the committee reports as they are, Your Honor, without cross-examining the witnesses of the prosecution. The impeachment court cannot just take the utterances, testimonies, the questions and answers, and the interpellations during the COJ and the CGGPA hearings as factual findings and statements of truth without going through the usual route of evidence presentation. In fact, Your Honor, we are even unsure whether these videos are spliced, edited, or shortened, with due respect, and whether the TSNs are accurate and edited or modified, as portions of the TSNs turned out to be different to our transcribed notes, which leads me, actually, Your Honor, to my second point. That because the matters covered by the pieces of evidence, Your Honor, which the prosecution would like this court to take judicial notice, are exactly the matters that are being heard before this impeachment court, the respondent must be given an opportunity to be heard by way of cross-examination before the court admits in evidence the TSNs, the video recordings, and the committee reports. The requirement of due process is basic. It is the opportunity to be heard before the court, and affording the respondent the opportunity to cross-examine to cross-examine the authenticating witness serves a dual purpose, Your Honor. First, it validates the existence of the video recordings, the TSNs, and the committee report. And second, it verifies their accuracy and completeness. The Constitution explicitly guarantees the respondent's right to ensure that these pieces of evidence have not been altered, edited, or modified to fit the prosecution's narrative of Article 1. Consequently, the respondent is fully entitled to have all the observations, the objections, and cross-examination questions placed on record before the court admits these documents in evidence. It is also a matter of record, Your Honor, that the videos that the prosecution would like this court to take judicial notice were not played during the pre-trial conference, Your Honor, and it is with the understanding between the parties that there shall be subjected to proper authentication and identification during trial, consistent with the rules of court. And third, the respondent has directly challenged the House of Representatives Committee on Justice proceedings before the Supreme Court, Your Honor, characterizing them as a mere fishing expedition and an unauthorized mini trial, Your Honor. Consequently, the respondent declined to participate in these proceedings, maintaining that the HOR COJ lacks the jurisdiction to conduct these trials.